Welcome to the story of Danielle Stislicki. Police know who killed Danielle Stislicki. Her parents know who killed Danielle Stislicki. Hell, even the court knows who killed her. So why is there still no justice? Because the truth was found the illegal way. So let's get into what happened. On December 2, 2016, 28-year-old Danielle Stislicki left work in Southfield, Michigan. She told a friend she'd swing by her apartment before dinner, a routine that would later haunt everyone who knew her. That night, she vanished without a trace. The next morning, her SUV sat parked outside her Farmington Hills home, keys inside, purse untouched, as if she'd stepped out for groceries and never returned. When someone disappears like that, with no clues, no calls, no bank activity, police don't assume a personal choice or spiritual retreat. They assume foul play. Danielle wasn't a mystery. She was a daughter, a sister, a friend, and her absence left a void no one could explain. Her mother, in the earliest days of the search, made a statement that echoed across every news broadcast. Danielle would never just disappear on her own. And her best friend later said it even more bluntly, "I just want him to talk and tell us where Danielle is." These weren't speculative comments. They were rooted in the fundamental knowledge of who Danielle was. Someone who showed up, who called home, who didn't vanish without explanation. From the start, law enforcement treated this as a case of what happened to her, not what she chose to do. That early sense of wrongness didn't come only from the abandoned Jeep. It came from the inconsistencies that began to surface when detectives interviewed people who had seen her in her last hours. Among them was Floyd Russell Galloway Jr., a co-worker and security guard at the building where Danielle worked. Witnesses placed them together in the office parking lot the afternoon she disappeared, him with the hood of his car up on his Buick Regal, as if it was having mechanical issues. Some even reported seeing him in the passenger seat of her Jeep as it left the lot around 5 p.m. Shortly after that, Danielle's phone pinged from the tower nearest Galloway's home in Berkeley. When police first spoke to Galloway, he didn't have a rock-solid story. He gave himself a blanket alibi that he worked every weekday in December. He claimed specifically that he was at work from 3 p.m. to 11 p.m. on December 2. While he was visibly shaking during his interview, it was later found to be that he called off work for a doctor's appointment. When someone's explanation doesn't match the evidence, detectives pay attention. And people close to Danielle remarked that Galloway's behavior toward her was unusual, too attentive, too focused, too persistent for something as simple as workplace friendliness. Texting her, leaving flowers at her work desk, perusing her aggressively. Law enforcement didn't take that lightly. Within just a few days of her disappearance, an immediate reward was announced for information leading to what happened. Not weeks later, not when leads dried up, right away. An early reward signals more than just hope. It signals that investigators believe someone with key knowledge is choosing silence over cooperation. At the time, Galloway wasn't just another person of interest. But he was right at the center of the perimeter, physically, circumstantially, and investigatively. The timeline of events made him unavoidable. The proximity of his last confirmed sighting with Danielle, the unanswered questions about his whereabouts, and the witness accounts that tied him to her final known movements. What investigators didn't know then, and wouldn't fully understand until much later, was that another violent episode involving Galloway occurred months earlier. On September 4, 2016, a woman jogging in Hines Park was attacked, dragged, punched, and choked, strangled, and the perpetrator attempted to sexually assault her, further tried to drag her to a far more secluded area. She managed to escape and called 911, but at that moment, investigators did not yet link that attack to Galloway. It was an unsolved crime, an open investigation. No arrest had been made, no suspect identified, and certainly no convictions. Everything changed, not because police were already hunting him for that crime, but because the investigation into Danielle's disappearance gave them the tools to connect the dots. In December 2016, as part of the Stislicki investigation, police obtained Galloway's DNA and cell phone records, along with cell tower data. As those forensic matches came in over the following months, they linked him to the Hines Park assault. That connection led to his arrest on June 28, 2017. Eventually, for these crimes and to avoid an attempted murder charge, Galloway pled guilty via a plea deal that removed the attempted murder and is currently incarcerated, serving the remaining sentence of 16 to 35 years. In other words, the investigation that began with Danielle's disappearance exposed another crime, not because police were already on that case, but because the broader probe created the forensic opportunities to link the elements together. That sequence matters. Galloway wasn't known to police as a violent offender at the moment Danielle disappeared. He became known because police followed the evidence that grew out of her disappearance. By March of 2019, The Michigan Attorney General's office believed it had gathered enough circumstantial evidence to file first-degree premeditated murder charges against Galloway in Danielle's disappearance. A bold step when there is no body, no confirmed cause of death, and no direct confession. But prosecutors felt they had a strong web of circumstance, opportunity, inconsistent explanations, witness placement, and behavior that raised red flags. They had performed a search warrant where it was found that a section of his bedroom carpet had been freshly replaced. DNA from adjacent carpet had very strong support for Danielle to be a contributor, and they found that he bought a new comforter December 4, 2016. Just 2 days later, they have her phone pinging between his house and her apartments around 8 p.m. the night she disappeared. Cameras have a vehicle on camera consistent with hers. They have camera at Tim Hortons near Danielle's apartment with Galloway getting a coffee and using a phone around 8:40. They have a taxi picking him up and taking him to his car near their work around 9 p.m. They have her car key and Fitbit found in the area between the apartment and the Tim Hortons. They have a vehicle consistent with his driving the route back to his home from work at approximately 9:35 p.m. Then came the most consequential legal blow of the entire case. About a week after Danielle vanished, Galloway's, because they were questioning him, got himself a legal defense attorney, and that defense attorney arranged for him to take a polygraph test, not at the request of police, but as part of building a defense strategy. In legal terms, that made the results and the information acquired attorney-client privilege, protected from disclosure because it was intended to help the defense prepare for prosecution. Normally any third party would break attorney-client privilege or not be covered under it, except for certain experts who would fall under what's called the Koval doctrine, meaning if the expert is necessary to help the lawyer understand or handle the client's legal matter, that communication must stay privileged, even incriminating communications. And unfortunately, the polygraph examiner, a former FBI agent, inexplicably shared privileged details from that session with a police chief friend. That friend, in turn, passed the information anonymously to investigators. Detectives followed that tip to recover critical items, including Danielle's Fitbit and her car key, and it opened new leads that became central to the state's narrative. The problem wasn't that the evidence was useful. The problem was how it was obtained. Under long-standing U.S. constitutional principles, anything derived from privileged information is considered fruit of the poisonous tree, evidence tainted by its unlawful or improper source. Attorney-client privilege exists to ensure that someone facing prosecution can speak candidly to their defense team without fear the government will exploit those conversations. When privileged material is leaked and used to generate new investigative leads, the courts almost always suppress those leads to protect due process. In this case, that legal doctrine wasn't theoretical. It was devastating. Multiple courts threw out crucial pieces of evidence because they stemmed from that polygraph tip, including location data, surveillance footage leads, witness statements tied to the tip, and other derivative information. Evidence that prosecutors had thought would form the backbone of their case was essentially wiped off the table. Fitbits, keys, phone traces, all inadmissible because they grew from an improperly shared secret. Suddenly, the state's case lost its biggest arrows in the quiver. What had once looked like a strong circumstantial framework now looked like a puzzle with half its pieces missing. Meanwhile, the family kept waiting. No body, no definitive resolution. Days turned to months, months turned to years, and every court hearing, every motion, every suppression ruling dragged the timeline further out. Danielle's father put it succinctly at a pre-trial hearing: "We know who killed Danielle." Her mother echoed that sentiment, describing the exhaustion of watching legal maneuvers grind progress to a halt. Her best friend spoke of tattoos in Danielle's honor and the pain of anniversaries that became ritual reminders of loss rather than celebrations of life. The case was scheduled for trial, only to be delayed once again. As of now, the next date set is February 2026, almost a decade after Danielle disappeared. What remains is a tapestry woven of emotional testimony, legal technicalities, and unshakable belief on the part of some that justice has been delayed but not denied. In the end, the Danielle Stislicki case is not just about a disappearance. It's about how the legal system balances the rights of the accused against the pursuit of truth, about how evidence is gathered and protected, and about the families who live in the gap between what happened and what can be proven. Danielle mattered, her life mattered, and the law, for all its brilliance and imperfection, should serve both innocence and accountability. This case is far from over. If you or anyone watching knows anything about what happened to Danielle, no matter how small, reach out to the Farmington Hills Police Department. A life stolen deserves justice. Thank you for watching. Please remember to like and subscribe. Until next time, this is Lori Facts, Uncommon Common Sense, meets Common Chaos, signing off.